and go to the about 10th last line of the next page.
जी आप 10th last line 4th line से पढ़े. It was इनका जजमेंट का रेफरेंस दिया गया. अभी जो हामिद खान साहब ने जो रेफर किया है इसके जजमेंट का रेफरेंस दिया है इसमें. ये पढ़े आप, इसी कंटिन्यू करें इसको आप.
जी सर, जी.
In the case of Justice Shaukat Aziz Siddiqui and
in the case of Justice Shaukat Aziz Siddiqui, the Supreme Judicial Council procedure of inquiry was held by the Supreme Court of
KPLD 2018 Supreme Court 538 इसका रेफरेंस है. जी कंटिन्यू करें.
जी. To be constitutionally valid and compliant with university accepted principles of due process. In the present matter, initial scrutiny of information was conducted in terms of paragraph 7 of the said procedure of inquiry.
ये जो मैंने पढ़ा था.
A discussion and inquiry into the information was undertaken in terms of paragraph 8 of the procedure of inquiry. A decision was taken to proceed against Justice Siddiqui and a show cause notice was issued to him along with the supporting material calling upon him to explain his conduct. And after receipt of his 2 replies, the council had met and they decided to proceed further with the matter in terms of paragraph 9 of the procedure of inquiry. And thereafter the Attorney General for Pakistan was required to conduct the proceeding in terms of paragraph 10 of the procedure of inquiry. After that stage of the proceeding, the said procedure of inquiry remains silent regarding the procedure to be adopted or followed in a given inquiry. And the council is extended the necessary discretion to adopt any procedure which may be found by it to suit the requirements of the inquiry. Such discretion of the council is manifestly explicit from the contents of paragraph 8(7) of the procedure of inquiry, according to which, without prejudice to the foregoing, the council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by the council to be just and proper in the circumstances. As the proceeding against Justice Siddiqui were based squarely upon the making of the above mentioned speech by him and the multiple and pervasive allegations leveled by him.
वो बताना चाह रहे सलाउद्दीन साहब, इसमें बताना चाह रहे कि हमने इंक्वायरी कर ली है. उनका कहने का ये मकसद है कि इंक्वायरी हो चुकी है, हमने अपना प्रोसीजर अडॉप्ट कर लिया. आपसे एक सवाल, आपकी बात अगर तस्लीम की जाए कि इनके हद तक सेटिस्फाइड कर दें, इनका स्टेटस बहाल हो जाएगा, और दूसरे पोर्शन में जो इंक्वायरी आप कहते हैं वो अलग से कंडक्ट हो. सपोज हम आपकी बात मान लें, इंक्वायरी कंडक्ट होती है, उस इंक्वायरी में ये हम ही करते हैं और ये साबित होता है कि इनकी एलिगेशन गलत थी, फिर क्या होगा? इनका स्टेटस वापस लिया जाएगा? कौन लेगा?
सर इसमें फिर ये होगा कि there would be it would be then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
please let it go. If you want to contribute, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't. If I was to deconstruct what you are saying, first of all, it's a never-ending thing ever. Let's take logically what you're saying, as what my lord had put to you, that if the petitioner's this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of what this inquiry is held, either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the report of the commission too does not automatically affect.
First tell us who creates this commission.
It is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
is a commission of inquiry or determine something that this judge had not stated the truth earlier, he will be persecuted for perjury.
My lord, it prepares a report. That report is then forwarded to the relevant body.
आप बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
The criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or sub-inspector in police.
If a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to.
Qazi are not quite getting traction with me, at least. कोई और बात करें या if you want to file, refer to. You are not sorry, but you're not referring to any precedent, any law, I mean, these are just opinions stated at the bar. कुछ और हमें बताए ना, कुछ चीज तो बताए ना, कुछ आगे बढ़ने वाली बात.
अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसेज
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें, बिकॉज हमें समझ नहीं आ रही बात, एंड वी आर मे बी यू हैव गॉट बेटर आइडियाज, यू कैन पुट देम इन राइटिंग एंड वी विल कंसीडर देम.
May I just summarize the...
No, please do so in writing, because you will carefully think out everything, and I'm sure it will be, because it's also 10 minutes to 2. आप हमें writing में दे दें, we will certainly consider it.
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूं. ये कह रहा है कि इफ ऑन इंफॉर्मेशन फ्रॉम एनी सोर्स द काउंसिल और द प्रेसिडेंट इज ऑफ द ओपिनियन दैट ए जज ऑफ द सुप्रीम कोर्ट और ऑफ ए हाई कोर्ट मे बी इनकेपेबल ऑफ प्रॉपरली परफॉर्मिंग द ड्यूटीज ऑफ हिज ऑफिस बाय रीजन ऑफ फिजिकल और मेंटल इनकेपेसिटी और may have been guilty of misconduct, यानी कि 2095 का ए या बी दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा. यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने. बात हुई इंक्वायरी के हवाले से तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट में नहीं की गई. टॉकिंग फॉर माई सेल्फ, ठीक है. तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने के जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटीग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस. नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? Institution of justice are high courts and the supreme courts. तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स? तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है. माजरत के साथ इंक्वायरी के हवाले से तो जरूर हमें मिली है कि ये इंक्वायरी नहीं हुई और इन लोगों को बुलाया नहीं गया, लेकिन वी हैव नॉट बीन प्रॉपर्ली असिस्टेड. टॉकिंग फॉर माई सेल्फ विद रिगार्ड टू द एस्पेक्ट ऑफ मिसकंडक्ट जो कि आर्टिकल 209 के बी के अंदर फॉल करता है और जो कि साफ साफ कहता है कि अगर मिसकंडक्ट होगा तो आर्टिकल आर्टिकल 209 लगेगा। इसके बारे में आपका क्या कहना है सलाउद्दीन साहब?
मैं जरा ऐड कर दूं माइलॉर्ड की बातों में। क्या जो तकरीर की थी वो मिसकंडक्ट में आती थी?
यस,
उसके लिए इंक्वायरी जरूरी थी?
यस
सर, मेरी दो सबमिशन होंगी इसमें। फर्स्ट ऑफ ऑल, if what he said in his speech was factually incorrect, then it was misconduct. If it was not factually incorrect, if he had correctly stated the facts, then it was not misconduct. Number one. Number two, sir, the other reason why it was necessary to assess whether the allegations were true or untrue was because it would affect the proportionality issue. If, for example, all these allegations were correct and the only grievance was कि ये आपने public speech में नहीं बातें करनी थी, तो then perhaps the SJC, the proper course for the SJC would not to be to remove the judge altogether. The punishment also has to meet the crime and doctrine of proportionality. जनाब ने अपनी कई judgments में
Saraji Sahab, I understood your first point. As far as your second point is concerned, there is no other option. ये तो नहीं है कि इस साल इंक्रीमेंट नहीं मिलेगी या दो withholding pays हो जाएंगी. Either you remove a judge or you don't remove a judge. Full stop. There is no proportionality involved in 209 at all. I don't know where you're getting this proportionality element and introducing it into the SJC. Rap on the knuckles, be a good boy, don't do it again. You know, that they can't do. Either they dismiss the complaint or they sustain the complaint and give a finding of misconduct and recommend his removal. That's all. Where's proportionality? Where are you getting this from in 209?
My lord, the court can certainly not give a lesser punishment. Your lordship is
It's not a court, it's Supreme Judicial Council we're talking about.
Yes, sorry, the Supreme Judicial Council. The SJC cannot give a lesser punishment, and your lordship is absolutely right. The question is whether the misconduct complained of is serious enough to justify removal. Your lordship will appreciate that the code of conduct says, for example, that a judge should not be rough in his conduct. Complaints are made against judges that they are rough in their conduct. On those complaints, the SJC would not be justified in actually removing a judge for misconduct because such a penalty would be disproportionate to the complaint made. Because if your lordship sees the code of conduct,
you then agree? You agree with us? Not then, okay, we got it.
जी सर। अब सर एक और जो fact है, and
no, wait, the offer of filing something you're not availing, you want to conclude, it's up to you.
Sir, there's just one point that I would ask that your lordship hear me on. It'll take 2 minutes, sir. It'll take 2 minutes. If your lordship just sees the order, the report of the SJC, I page
8. Page 39.
Ji sir. Your lordship sees that the first note is sent by the secretary of the SJC.
Have you seen that already, Ji?
He is the complainant. Number 2 में अगर आप देखें sir, the chairman of the council passes an order that the Chief Justice of the Islamabad High Court may comment upon veracity of allegations.
Mr. Khan has already referred to it. Ji
sir. इसमें sir, the chairman of the SJC has directly started the inquiry
without assigning the
order.
Without assigning matter to the other.
ये अगर आप प्रोसीजर भी देखें रूल्स 4 to 9 and of course 209 ka 5 and 6, Article 209 ka 5 and 6, the SJC chairman has no role to play in terms of starting the inquiry. The inquiry has to be started by the Supreme Judicial Council. What is calling for a report from the Chief Justice of the Islamabad High Court and for evidence from Mr. Shaukat Siddiqui, that itself was the inquiry. That is an act totally without jurisdiction, and the entire superstructure based on that falls, sir.